Corrupt federal judge Eileen Cannon strikes again. I did a previous hot take on the special counsel's team informing Judge Cannon she did not include a critical date, the most critical date in any case involving classified information in her revised scheduling order. So they proposed a date when this most critical date should take place based on her revised scheduling order. Judge Eileen Cannon just responded in one of her infamous paperless orders where she denied the government's request and said that she will revisit the most critical deadlines after her March 1, 2024 scheduling hearing, which confirms everything we've been saying about Judge Eileen Cannon, which is that the May 2024 trial date, which she has not adjourned in her revised order that was issued on November 10th, is totally fraudulent, totally phony. She is keeping that May 20th, 2024 trial date that she previously set as a way to try to box out any other trials from taking place at that time period to protect Donald Trump. We called it first here on the MeidasTouch Network. I'm Ben Meiselas. For those just watching the MeidasTouch Network for the first time, welcome. This is where facts matter. We go through the paperless orders and we give you top-notch legal analysis of what is actually taking place here, not just the words, but what's going on behind the words and what their imputation is. Here's the paperless order that was just issued. Paperless order denying without prejudice motion for SEPA Section 5 notification. As stated in the court's November 10th, 2023 order, all previously remaining deadlines in the court's July 21, 2023 order are suspended except calendar call and trial. The court reset the first set of pretrial deadlines as indicated on page 8 and 9 of that order and scheduled a conference on March 1, 2024 to address remaining deadlines. To the extent the special counsel's motion seeks reconsideration in part of the court's November 10, 2023 order, that request is denied. SEPA Section 5 deadlines and all other pretrial deadlines not included in the first batch of pretrial deadlines contained in the court's revised scheduling order will be set following the March 1, 2024 scheduling conference. And folks, her corruption is just matched by her incompetence. She's never had a Classified Information Procedure Act case before. And what makes her worse than just how corrupt she is she's so arrogant. She's so Trumpy. She pretends like she knows SEPA when she knows nothing about SEPA. This isn't just some random deadline, Section 5. In any case involving classified information, as the Mar-a-Lago document case before her is, the SEPA Section 5 is the main pretrial deadline. So by not setting that hearing date and setting other hearing dates, it just creates a ton of confusion, a ton of delay, a ton of problems that will inevitably take place in this case. And how do you handle the classified information? What documents are we dealing? What is the corpus of documents in this case? Because you have to go through in SEPA Section 3, SEPA Section 4, SEPA Section 5, SEPA Section 6, and so on. And these things happen in an orderly way. These aren't issues of first impression, folks. Courts know how to deal with SEPA, the Classified Information Procedures Act. This is not how you deal with SEPA. You've got your SEPA Section 3 protective order, has to be entered. It took Judge Cannon 3 to 4 months to sign the freaking SEPA Section 3 protective order before Special Counsel Jack Smith could even turn over all of the documents. Jack Smith's turned over about 5,500 pages of classified information. Then you go to SEPA Section 4. SEPA Section 4 is where the government says that we are going to withhold certain documents because they're so highly classified from discovery, and on a in-camera, ex parte basis, Judge, we are going to go to you, just show you the other side isn't allowed to take a look at it, and then we determine if we're allowed to withhold certain documents because they're so classified that they don't get produced. And then we determine, do there have to be redactions? Do there have to be substitutions? Do we substitute a summary in place of example turning over the actual nuclear records and the nuclear secrets and the war plans, because what you want to avoid with SEPA is something called gray mailing. And what Judge Cannon is allowing Trump to do here, it's so overt, is to try to gray mail the government, which is a form of blackmail. It's to say, aha, you want to prosecute me? Well, I'm going to make our nuclear secrets public. You want to prosecute me? I am going to make our war plans public. You want to prosecute me? I'm going to make this all available to the public, destroy our national security, or this is where the gray mail comes into place. You could dismiss this charge or dismiss this count, and that's why you have an orderly process in SEPA that was passed decades ago by the United States Congress to deal with these issues that all of the other courts follow, except the corrupt and incompetent Judge Eileen Cannon. So SEPA Section 5 is the most basic of notices, where already 5,500 pages of classified documents were turned over to Donald Trump's team. They have the records. Under SEPA Section 5, they're supposed to give notice to the court which of these documents they intend to use at trial, so then the government can respond through the SEPA Section 6 process, why this all takes time, to make the arguments why certain documents need to be, there has to be substitution, redactions, certain documents can't be used. Then the judge makes decisions on whether there could be redactions, whether there could be summaries in place of the actual documents. And then those things are then subject to immediate interlocutory review by the Court of Appeals, which Cannon's so going to be overturned on. And she knows she's going to be overturned once she makes those decisions. But her whole plan, and it's so transparent, is just because trial judges, federal judges, have a ton of discretion when it comes to scheduling their docket. If they just say, it's a scheduling issue, the Court of Appeals can't intervene. So you may be saying, why doesn't Jack Smith go to the 11th Circuit and shout out on the rooftops, look what Judge Cannon is doing, look how corrupt this is? Because it's the way Judge Cannon is framing it. And this is the lesson she learned when she was overturned twice in 2022. It's the exact wrong lesson. The right lesson when she was overturned twice for accepting equitable jurisdiction over the search warrant involving Mar-a-Lago, which she shouldn't have had, when the 11th Circuit said you violated the law by accepting jurisdiction. It should have been follow the law, Cannon, but that's not what Cannon did. Her thing is, let me not make rulings to help Donald Trump that could be appealed right away, and then let me drag this out, let me delay this, and then I can't get overturned, and therefore I could help drag this out for Donald Trump and help him delay. Because what happened right away, and this happened on Wednesday night, Special Counsel Jack Smith filed, hey, Judge, you left out, let's hear, I'll pull it up right here. This is the judge's scheduling order from November 10th. Special Counsel Jack Smith is like, hey, Judge, you left out SEPA Section 5 from your scheduling order. You see it right here. It has a scheduling conference March 1, 2024, where she doesn't adjourn the May 20th, 2024 trial date. She keeps that in place, but she set that scheduling conference, right? Remember what I said as soon as she set that scheduling conference? I said, she's doing that. She's going to change the trial date around March 1, 2024, but she's setting that 4 days before the Washington, D.C. federal case, which is March 4th of 2024, so Cannon can see how she can help Trump when it comes to that May 2024 trial date. That's why she set it March 1, 2024. She knows about the March 4th, 2024 trial date. That's why Cannon said it March 1, 2024. All these other pre-trial motions don't mention SEPA Section 5, which is critical to then go to the other SEPA sections that then need to be followed. So when I saw this, I said, she's missing the key date. And she now, Jack Smith has smoked it out, at least, by filing this notice where he's like, yeah, you didn't include this date, the key date, SEPA Section 5, which is going to delay everything if we don't have that date. And so she had to respond, that's the way I intended it. I'm not going to give you clarity on SEPA Section 5. And all this does is actually harm our national security. This is gray mailing. This is blackmailing, because the subtle thing that's going on here is basically saying, well, she doesn't say it, but or you could dismiss this count or that count. Then we won't have any SEPA Section 5 issues or SEPA Section 4 issues. We won't even have to get into SEPA Section 6 about the redactions and substitutions. What are you going to do there, Special Counsel Jack Smith? This is atrocious, atrocious conduct right here. But folks, the one thing I want to remind you of, we still have that Washington, D.C. trial before Judge Tanya Chutkan, who actually follows the law. Judge Chutkan was confronted with some SEPA issues as well. Handled it the way every other judge in the country handles it. You don't even hear about this mess because Judge Chutkan's like, yeah, this is what the statute says. I follow the law, because that case involves classified documents also, and Donald Trump trying to graymail and blackmail. She's like, just follow the normal SEPA section. Only Judge Cannon does this, and it is the height of corruption, and it totally exposes what her plan is by saying that she's not going to in any way set a SEPA Section 5 deadline in her pretrial order until after March 1, 2024. Makes the May case impossible. It exposes everything. And folks, as corrupt as you get right there. But there you have it. I'm Ben Meiselas from the MeidasTouch Network. The one mistake that she made, though, that really kind of ended up screwing her, and she realized that she made it, is she moved the trial date back to May, which allowed Judge Tanya Chutkan to set the trial date in March. And Judge Cannon wishes she didn't make that mistake. That's why she's protecting that May 2024 period right now, because she realized, that's what I should have done. And now she's trying to make up for it by engaging in all of these other machinations. Hit subscribe. We're on our way to 2 million subscribers, and thank you so much for watching.
Hey, Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.